So on March 23rd, U.S. Citizenship and Immigration Services, they announced it has ended certain flexibilities it first announced back in March of 2020 to address the COVID-19 pandemic. And during the pandemic, an additional 60 days was added to deadlines to respond to almost any notice from immigration. So whenever anyone got a notice from immigration, they said respond in 30 days, 60 days, you got an extra 60 days because of COVID. That included requests for evidence, continuations, notices of intent to deny, notices of intent to revoke, notices of intent to rescind, notice of intent to terminate, notice of intent to withdraw temporary protected status, motions to reopen on citizenship, and all appeals. Whatever the deadline was to respond to an immigration notice or to do an appeal, you got an extra 60 days up until March 23rd of this year. That's when the COVID protocols ended. So any notice that anybody receives now must be responded by the date on that notice. Any notice that's mailed after March 23rd. Any notice mailed before March 23rd, dated before March 23rd, you get the extra 60 days. And most of these notices that I just mentioned, you have a 30-day turnaround. So it's going to be much more difficult to respond to RFEs and notices of intent to deny, etc. The one COVID rule that stayed permanently relates to the reproduced signatures. That's photocopies of signatures or electronic signatures. They're acceptable on all immigration forms. You don't need the wet signature anymore. The wet signature being, your inked pen. So you don't have to have an inked pen signature anymore. And that's also a result of COVID, but they made that permanent. So you don't need to have any of those wet signatures, as they like to call it, on immigration forms. You can use electronic signatures or anything off a computer, or a photocopy of anything off of a computer. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.